I think we might get started, thanks. Thank you everyone for joining us for this afternoon's session. I'd like to acknowledge the traditional custodians of the lands on which we meet, the Gadigal people of the Eora Nations, and pay my respects to their elders past and present. And I pay those respects as well to all Aboriginal and Torres Strait Islander people here today. Today we have two very topical and important papers, especially relevant to someone like me coming from the ACT. I will take our speakers' illustrious bios mostly as read, but I'd first like to introduce Julia Quilter, Professor of Law at the University of Wollongong, who will be speaking with Professor Luke McNamara, currently based at the University of New South Wales and previously Dean of the Faculty of Law at the University of Wollongong. They will be speaking about their analysis of transcripts in 75 sexual offence trials that ran to over 31,000 pages of transcripts, which is quite a monumental task in terms of time and coding and vicarious trauma. So thank you, Julia and Luke. They will speak for 40 minutes and then we will have the other paper. Because the topics are so linked, we'll leave the questions till the end of both papers. So over first to Julia and Luke. Thank you very much. Point it over there.
Point it over here? Excellent. Thank you for that warm welcome, Lorana, and it's great to be with you all today. I want to situate this study that we've completed within the context of 40 years of progressive legislative reforms. And I haven't done the first thing, no, I have, I'm all right, good. 40 years of progressive legislative reforms which have collectively attempted to reshape the laws relating to the prosecution of sexual offences. And while our study relates to New South Wales, it is the case that those reforms have been ongoing across Australia. While evaluations of various amendments have been undertaken, there has not been a study of this significance in terms of the number of trials looked at since the Heroines of Fortitude report was done by the Department for Women back in 1996. We feel privileged, have I managed to skip a slide, sorry. We feel privileged to have been commissioned to undertake this study as part of the New South Wales Government's implementation of a recommendation from the New South Wales Law Reform Commission in its inquiry into consent in relation to sexual offences. And that was, and I quote from the recommendation, the New South Wales Department of Communities and Justice should fund research about the experience of complainants of sexual offences in the New South Wales criminal justice system. We especially acknowledge the complainants in the sexual offence trials examined in this report. Although we never met them, their stories are at the heart of this story, and their voices are present in anonymised form throughout the transcripts that feature in the report in my presentation and in Luke's presentation today, as well as in the published report. The aim of this commissioned research was to investigate really the experience of complainants in sexual offence trials in the District Court of New South Wales, with specific attention to matters such as those that are, I can see it down here, silly me. Sorry about that. The operation of legislative and privacy protections, examination in chief and cross-examination approaches, and judicial interventions and directions. We were guided by a range of questions, and those questions had a pretty common theme, of which this investigation looked into the adequacy of the existing arrangements for meeting the legitimate needs and expectations of complainants. As Lorana has already mentioned, the data set for this study consisted of 75 sexual offence trials finalised in the New South Wales District Court between 2014 and 2020. Although not a representative sample in the strict sense of that term, the sample was created with an eye to diversity in relation to factors like court location, nature of offences charged, and complainant demographics. This was primarily a qualitative study, although we also undertook some basic numerical calculations, and some of which we will share today and which are detailed also in the published report. All transcripts were read by a member of the research team. We used NVivo as a platform for data storage and coding, but we did not use any computer-based or AI-assisted technologies for content analysis, and I think that's just important to clarify that. We'll present our findings basically in 5 parts. As you can see, I'm going to start, then I'll hand over to Luke, and then I'll come back again to talk about some of our conclusions and some of our suggestions. So the first part of the talk is really related to those general and special protections for complainants. So what are they? You can see a great list here. Motivated primarily by a desire to reduce the trauma associated with giving evidence at trial, multiple changes to the traditional trial format have been made over the years. They include general protections that are operating in basically all trials, such as things like closed court arrangements or giving evidence by way of CCTV from a remote location. But there are also, of course, specific protections that are activated if raised in the relevant trial. So to give one example, it might be that where a trial has run but has led to a hung jury, the evidence that has been recorded can be replayed in a new trial, rather than the complainant, of course, having to give that evidence again, which can be very difficult. So turning first to those general protections, these largely appear to be operating effectively in most trials. So this is kind of our good news story, including alternative arrangements for giving evidence and non-publication arrangements, really as standard practice. We did notice that some of the closed court procedures were somewhat ineffective at times, with members of the public being able to access or enter the courtroom even though it was closed. In addition, some classes of individuals were regularly exempted by judges from those closed court procedures. For example, parents of the accused and sometimes a current partner of the accused. In terms of specific protections, and I've mentioned one, but also sexual communication privilege, these basically rarely operated in the trials in our study, with one exception, and that was in relation to sexual experience and sexual history evidence. And these were raised in basically 50% or half of our trials, that is 38 trials. We found that usually there was pretty good compliance with the legislative regime that is set out. So, for example, an application before the trial commenced with submissions and a ruling in terms of the nature and substance of the questions to be asked. So that was again good. But in some trials there was no such application, really leaving counsel to scramble with objections or the judge to deal with it on the run, and a further discussion with the jury not present. Notably, this study's findings, I think it's important to say that while we found the process was working relatively effectively, there's really no grounds for suggesting that the rape shield law in New South Wales is leading to some notion of a fair trial, and that has been something that's been raised in New South Wales because we don't have a residual discretion. Indeed, the gateways seem to be allowing most questions to be asked by counsel that they've requested to ask. So I want to turn now to the Crown case and away from those general and specific protections. And we did find a number of things in relation to the Crown case. There we go, managed to turn the slide, that's good. Generally, we found that the Crown was sensitive to the complainant, including being very responsive to complainant distress and the need for breaks. We were surprised, though, about the frequency with which detailed questioning of sexual acts or body parts occurred, given that we know that that can be incredibly distressing for complainants in front of strangers. At times, insistence on formal terminology really appeared to be inconsistent with a complainant's preferences for a more vernacular form of words to be used, and sometimes produced confusion and indeed embarrassment. So using a term was required, like ejaculation rather than cum, things like that. And the level of specificity of sexual acts was being required in the questioning by the Crown that really had the capacity to cause complainant distress. And often sexual intercourse in these matters was not disputed. So again, the question I suppose might be why that level of detail being asked. In terms of the form of examination in chief, we didn't find any instances in which the court ordered to allow the complainant to give evidence in narrative form. Nevertheless, there were a number of trials where, in effect, that was what happened. So very open-ended questions like, so what happened next, and then what happened, and then what happened. And that really did seem to afford the better opportunity for a complainant to tell the story in their voice. And I think it's important to note, in those cases where that kind of open style of questioning was used, there were no real defence counsel objections, or very few. So I think that's quite an important finding from our research. On the other hand, where the Crown generally kind of relied on a step-by-step sort of process, really trying to close the questions down around the complainant, at times that did lead to confusion and indeed the complainant indicating, I just can't remember. In terms of the overall running of the Crown case, we really found it was a fairly formulaic approach, including the types of evidence led, which on our assessment were not necessary or valuable. They may have been strictly relevant, but in the evidence law term, but we would suggest perhaps not especially valuable. So things like DNA and forensic evidence and medical evidence, which was respectively led in 68 and 71% of trials, and that was despite the fact that the accused's identity was known and often that sexual intercourse was typically conceded. CCTV footage, 35% of cases, and text messages, 67% of cases, were also often led, despite what we found was fairly tangential relevance, with some notable exceptions, of course, where the CCTV footage actually captured some or part of the events. We were also surprised at the number of questions about attire, including details of underwear, despite little or no relevance. Indeed, in one case, the Crown asked 27 questions of the complainant about what they were wearing, which was a onesie leopard skin, a leopard print, and how it came off during the events in question. And perhaps, this was it was quite understandable that this led to complainant distress. Scholars for some time, such as Susan Estrich back in the 1980s, have employed the concept of the real rape to draw attention to the way that culturally, and indeed now legally, stereotypes and expectations have informed assessments of whether a victim's allegation of sexual violence is genuine. These so-called real rape attributes are features of the events and the victim's responses that serve to validate an allegation as true or indeed, of course, as false. These include expectations that a genuine victim will verbally and physically resist the sexual assault and will make an immediate complaint. Of course, such attributes are at real odds with the available evidence about the circumstances in which acts of sexual violence occur and the diverse range of ways in which a victim of sexual violence might respond or behave in the aftermath of a sexual assault. Legislative amendments to substantive offence definitions and educative directions to juries have attempted to combat these types of myths and expectations. In addition, as the quote on the screen indicates from Justice Natalie Adams, the New South Wales Court of Criminal Appeal has cautioned and this is again a quote from the same case, against the imposition of stereotypical expectations as to how complainants in sexual assault matters should behave. And a line of authority in the CCA goes back almost a decade in relation to those kinds of issues. Yet, such stereotypes and assumptions feature very prominently in the Crown case in our trials. 5 of the most common include evidence of immediate complaint, 73% of trials, supportive or corroborative evidence, 85% of trials, perceived complainant distress, typically by another witness or an ambulance officer or somebody else, 81% of trials, a focus on consistency of complainant accounts, 37% of trials, the complainant's verbal or physical resistance in 67% of trials, and an emphasis in and around injuries in 56% of trials. And this is the Crown we're talking about, emphasising these features. We really saw very little evidence that the transformed legislative definition of consent, which of course focuses on free and voluntary agreement rather than resistance and injuries, really didn't feature in the Crown's case at all. And you've got a couple of examples here of the types of questions that were being asked of complainants, which really go to the heart of continually asking about what the complainant did to resist or how they might have been injured in such circumstances. We found that really very rarely the Crown focused on that important definition of free and voluntary consent. Where they might do so, it's typically in opening and closing addresses, or to ask, for instance, a very simple question of the complainant, did you agree to this? To which a very short answer was typically given, no. Nevertheless, we did find that rape myths were challenged by the Crown in a majority of trials, 69% of those. But this was done usually where evidence was unavailable to support a correlating real rape attribute. Sometimes this was done by asking the complainant to provide an explanation or through another witness, such as a doctor, but most typically in closing addresses. And you've got an example here of that concept of the easy allegation to be made, to make that women lie about these sorts of allegations, being very much addressed in these closing addresses of the Crown. Of course, this may be important for specific trials, providing an explanation to juries or countering defence submissions. However, it really does very little to address the long-held and entrenched assumptions about how complainants should act, or that women lie about rape and that it is an easy allegation to make. So I'm going to pass over now to Luke, and I'll join you again shortly. Thanks, Luke.
So, turning to some findings in relation to features of the cross-examination of complainants. On formalities and style, Defence Counsel were generally courteous in their demeanour and tone towards the complainant. We did, however, observe some instances of repetitive questioning, confusing sequencing of questions, as well as instances of Defence Counsel being sarcastic, combative, belittling, and judgmental towards the complainant. However, in most trials, the most confronting aspects of cross-examination for complainants were not how they were questioned, but what they were questioned about. Before I turn to this topic, a quick mention of the rule in Brown and Dunn. This rule of practice provides that, as a matter of fairness, quoting from the relevant High Court authority, where it is intended that the evidence of the witness on a particular matter should not be accepted, that which is to be relied upon to impugn the witness's testimony should be put to the witness by the cross-examiner for his or her comment or explanation. In essence, this is the point in cross-examination where Defence Counsel puts to the complainant the accused version of events. Depending on how this part of cross-examination is handled, it can be confusing and distressing for complainants. We observed variability in how this was done, including in some cases an ambush style which appeared unfair to the complainants, as well as some good practice with clear upfront signposting, such as the example on the screen right now. Right now. A further dimension of the traditional expectation of immediate complaint was the expectation that the manner in which the details are subsequently articulated by the complainant should be consistent. Inconsistency has long been regarded as an indicator of lying. This expectation has been debunked by the research literature on memory, recall, and trauma, as well as the research on accuracy and deception. Nonetheless, in 76% of the trials in this study, the veracity of a complainant's account was challenged on the basis of differences between the account given at trial and the account given on a previous occasion, such as to a friend or family member, to a police officer, or to a doctor. There is potential unfairness and distress caused to complainants whenever they are questioned in a way that suggests that they have failed to deliver the consistency and the complete recall that is expected of a so-called good witness, especially when attention is drawn to alleged inconsistency that evolve into, as often is the case or was in the trials in this study, into a claim that the complainant is lying. And we'll talk about that a bit further later. This must be all the more distressing where the asserted inconsistency relates to minute details such as the precise location of hands, arms, legs, and other body parts, or matters of peripheral detail or dubious relevance. Since December 2018, Section 293A of the Criminal Procedure Act has allowed for a jury direction to correct the rape myth or misconception that inconsistency is indicative of fabrication. We will share our findings on the operation of this jury direction later. Here we simply note that we observe no discernible difference between trials conducted pre-December 2018 and post-December 2018 in terms of Defence Counsel's inclination to draw attention to differences in the complainant's account. The narrative that characterises the rape complainant as a lying woman has a very long history and was once solidly embedded in the common law. Although it no longer has the legal status it once had, that is, presenting so grave a risk as to warrant a mandatory corroboration warning, we found that an express or an implied suggestion that the complainant was lying in some respect was a very common feature of the trials examined in this study, occurring in 95% of trials during cross-examination. In almost 3/4 of the trials in this study, Defence Counsel attempted to advance a motive for the complainant making a false allegation, presumably with the aim of persuading the jury to accept the defence's preferred characterisation of the complainant and their evidence, or at least to regard it as a basis for having a reasonable doubt about the accused's guilt. We were struck by the range of suggested motives and, in some instances, their speculative nature. For example, it was variously suggested that the complainant was distraught that her GP, the accused, was leaving their medical practice and relocating. The complainant wanted her stepfather out of the family home because he had been preventing her from seeing her boyfriend. The complainant aimed to strengthen her application for permanent residency in Australia. The complainant wanted to force the police to take action on a non-sexual assault and breach of AVO on the accused. The complainant wanted compensation from the accused or victim's compensation to pay for cosmetic surgery. And one more, the complainant wanted academic consideration on a university assessment task. In most trials in this study, Defence Counsel were afforded extensive latitude to ask complainants about a wide variety of matters. This included instances where, from our point of view, the relationship of the question's subject matter to a fact in issue was not necessarily obvious. We note that the broad conception of relevance in Section 55 of the Evidence Act facilitates such lines of questioning. Topics regularly addressed during cross-examination in trials in this study included aspects of the complainant's present or past life that were implicitly raised to reduce their credibility, These included histories of substance use and addiction, mental illness, criminal convictions, and having had their children placed in out-of-home care. They included pre-event behaviour that was characterised as flirtatious and said to be indicative of consent. And they included post-event behaviour that was characterised as inconsistent with the expected behaviour of a victim of a sexual offence and said to be indicative of fabrication. Being questioned on such topics is likely to be a significant contributor to complainant embarrassment and distress, noting that it also extends the duration of the complainant's time on the stand. It was rare for such lines of questioning to be disallowed on the basis of relevance. A recurring theme in complainant cross-examination was the attempt to highlight those circumstances of the alleged sexual offence that were not consonant with the attributes of a so-called real rape. The table on the screen here summarises our findings on the regularity with which complainants were asked questions during cross-examination that sought to draw attention to the ways in which the complainant and their allegation departed from the hallmarks of real rape. Note the symmetry between these aspects of defence cross-examination of complainants and the manner in which the Crown presented its case, explained by Julia earlier. To put it another way, in many trials in this study, the prosecution and defence were playing different sides of the same coin. The Crown was engaging real rape attributes as indicative of the truth of the allegation and the guilt of the accused. The defence was presenting the absence of these attributes as indicative of the falsity of the allegation and therefore the innocence of the accused. The continuing prominence of delayed complaint lines of questioning is especially noteworthy, given that attempts to reduce the problematic correlation between speed of complaint and honesty goes back more than 40 years. We have highlighted some illustrative examples at the bottom of this slide, along with some illustrations of questioning that evoked other real rape attributes. A version of delay was suggested during cross-examination in more than 4 out of 5 cases in this study, including 18 cases where the complainant reported to police within 24 hours. The suggestion of delay included not simply temporal delay, as in taking too long, but other ways in which the complaint was imperfect. For example, telling the wrong person or providing insufficient detail. Shortly, I will report our findings on the operation of the jury direction on absence of delay in complaint in Section 294 of the Criminal Procedure Act. In fact, I'll turn there directly. We did look at the operation of jury directions, and you might know that this is an area of particular concern because recently, indeed June 2022, an additional 5 sexual offence trial-specific rape myth correcting directions were added to the Criminal Procedure Act. But just to be clear, in this study, only 2 of the current 7 relevant directions were in operation. The direction on lack of or delayed complaint in Section 294, which was first introduced in 1981, and the direction on differences in the complainant's account, which is in Section 293A and was added in 2018. The delay direction is designed to correct the rape myth and the traditional common law expectation that immediate complaint is a hallmark of a genuine complaint. It was given in 38% of the trials in this study, noting that on our analysis, the defence suggested that the complainant had delayed in some way in more than 80% of trials. The best uses of the delay direction were when it was given in an integrated form, sometimes referred to as a fact-based direction, that is, not just as an instruction, but interwoven with the facts of the case. The worst uses of the delay direction were when it was used in an abstract instruction mode and in conjunction with an old complaint direction with which it is in tension, because it tends to suggest that a genuine victim will act in a particular way, such as telling someone immediately. And there is an example of what we would regard as a problematic hybrid direction on the screen. Such a combination of conflicting directions is likely to be confusing to jurors and raises doubt about whether the intention behind the Section 294 direction is being fully realised. The differences in account direction in Section 293A is designed to discourage jurors from assuming that differences are necessarily indicative of unreliability or fabrication. Again, it seeks to correct the rape myth that a truthful victim will always provide accounts that are entirely consistent. This direction was introduced, as I've said before, on the 1st of December 2018, and so it was available in just under half of the trials in this study. The direction was given in just 34% of trials in which it was available, which is less than half of the cases in which, on our assessment, it should have been given. Neither the delay direction or the differences direction was given during the evidence phase of the trial, that is, when the complainant was giving evidence. If given at all, these two rape myth correcting directions were only ever given at the end of the trial during the judge's summing up. This contrasts with directions concerned with the rights of the accused, such as the direction that no greater weight or no lesser weight should be attached to a complainant's evidence given via CCTV, which were routinely given mid-trial at the time of the relevant event in the trial. We know that the research literature suggests that for maximum effectiveness and impact on the jury, directions should be given at the time of the evidence to which they relate. Before I hand back to Julia to offer some conclusions and suggestions for further reform, a quick comment on another direction that featured prominently in trials in this study, the so-called single witness direction, also known as a modified Murray direction. Now, this is not a legislated rape myth correcting direction. Rather, it is, on our analysis, a remnant of the old mandatory common law warning about the danger of convicting on the uncorroborated evidence of sexual offence complainants, which was abolished in 1981 and since 2007 expressly prohibited by Section 294AA of the Criminal Procedure Act. In 2015, the Court of Criminal Appeals saw fit to issue a reminder about the prohibition in the face of evidence of the continued use of Murray or single witness directions. Despite the clear rules and guidance from both legislature and judiciary, a single witness direction was still given in 25% of the trials in this study. The passage on the screen is illustrative. We note that in some trials, the trial judge expressly refused to give the requested single witness direction in light of Section 294AA and the decision in Ewan. This illustrates a point that applies to many of the findings of our study. Although all trials are governed by the same rules, we observed that there is considerable trial-to-trial variation, reflecting the fact that judges, as well as prosecutors and defence counsel, retain a significant degree of autonomy.
Thanks, Luke. So the findings of this study suggest that although discrete reforms to specific aspects of the criminal trial, such as alternative arrangements for giving evidence and restrictions on sexual experience evidence, are generally operating as intended, these measures have not significantly changed the substance of how sexual offence trials are conducted, including how the Crown frames its case, and in particular, how complainants are cross-examined by the defence. Our study suggests that rape myths and stereotypes, including fresh complaint, the old idea of raising the hue and cry, physical resistance and injury, evidence of complainant distress, and consistency of accounts continue to heavily influence the framing of rape trials, and that's so by both the prosecution and defence. In cross-examination, complainants are routinely accused of lying and of having failed to behave in the way that a so-called genuine victim of sexual violence would act. This is in spite of the fact that countering associated myths and stereotypes has been a central theme of statutory change for decades. And of course, in the face of repeated pronouncements by the New South Wales CCA discrediting these types of stereotypical assumptions about how victims of sexual violence should behave. Overall, we found that the problem is not that judges and lawyers are ignoring or misapplying the special rules that have been introduced for sexual offence trials. Rather, The problem is that the reforms of the last 40 years have attempted really only very modest incursions into the essence of what makes sexual offence trials so traumatic for complainants, including the adversarial nature of proceedings, the breadth and sensitivity of topics complainants might be asked to address, and the absence of substantive barriers to the evocation of rape myths and stereotypes. So, some modest suggestions, I think, for improvement appear there on the screen. One of the things that we think really needs to happen is that the Crown needs to change the way it presents its case with a much greater focus on the concept of free and voluntary consent. On the screen there, we've got what we thought was a very good practice example of the Crown in a closing address, talking about the concept of free and voluntary consent and integrating that with the evidence that had arisen in the trial. But there needs to be a reduced reliance on real rape attributes and associated evidence, and more space, we think, for the complainant's voice. We need a more robust and restrictive approach to the admissibility of evidence about the complainant and their actions. And I think we need a review of jury directions used in sexual offence trials with a focus on ensuring compatibility with the Criminal Procedure Act directions for sexual offence trials. And I think, we've had such a long period of time of relying on these types of directions that we really need to get them right and to ensure that there aren't those kind of inconsistent directions being given to jurors, because it must cause an enormous amount of confusion to them when they listen back to those kinds of directions. We've also suggested the introduction of ground rules hearings for all sexual offence trials, including advanced determination not simply of how questions are asked, but also what topics are being covered. On the last of these suggestions, we note that ground rules hearings are already in operation in New South Wales for vulnerable witnesses, including children. Last month, Victoria introduced ground rules hearings for all sexual offence trials, and it is really this approach that we are advocating for consideration in New South Wales. Of course, none of these suggestions is straightforward, but we think they are sufficiently grounded in the findings of this study that they do deserve further consideration and debate. Of course, they raise resourcing issues, and the possible implications for the rights of the accused will rightly need to be scrutinised. But we submit that they warrant consideration in the light of these findings, and also given the significant number of sexual offence trials that are really the basis of much of the district court's work at the moment. So in closing, we really want to thank the New South Wales Government and the Bureau of Crime Statistics and Research for this incredibly rare opportunity to access transcripts from sexual offence trials. We are committed to the view that law reform does not end with the passage of a bill or the commencement of a statute, and that it is really essential to document and evaluate what is happening every day in courtrooms. Victims, survivors of sexual violence, we think, deserve no less. All members of the research team, and they include Melissa Porter and Sarah Crossbury-Hewitt, who are here in the audience with us today, were honoured to have been given the chance to provide some insights in this regard. So thank you.
Thanks to Julia and Luke. And in reading the report, I really was struck by this, the more things change, the more they stay the same. I read the Heroines of Fortitude report when it came out decades ago, and so much of it was so familiar, in the sense that, the statutory reform hasn't yielded that much because, as you said, the prosecution and defence are playing two sides of the same coin, and a lot of it comes back to the rule in Brown and Dunn and having to think about how do we change that narrative within the paradigm of the adversarial system. and I think that Elena and Francis will have some suggestions for us in that regard. So the second paper will be presented by Elena Campbell, who's a lawyer, consultant and researcher who oversees research at the Centre for Innovative Justice at RMIT University, principally in relation to domestic, family and sexual violence and the relationship of trauma to people's contact with the justice system. And she's joined by Francis Lockie, an Associate Director at KPMG. Francis's work is primarily in relation to preventing and responding to gender-based violence, and Francis previously worked in the New South Wales Government. They will be talking about a report which is officially launched today, I think, also funded by Boxer, which involved focus groups with 118 professional stakeholders. That component was conducted by KPMG, and interviews with 34 sexual offence victim survivors, which was led by the Centre for Innovative Justice. Thank you.
Okay, it's very exciting to be up here today, and we were just commenting with the folk at Boxer that it takes a long time to get these pieces of work to come to light, and then all of a sudden they're here and we're talking about them, and it's a fantastic opportunity to be able to share the stage with Luke and Julia. So I'll hand over to Francis in a minute, but my name's Elena Campbell. I am from the Centre for Innovative Justice, or CIJ, at RMIT down in Melbourne, in Naarm, and it's a real privilege to be here on Gadigal country today to talk about our report called "This Is My Story, It's Your Case, But It's My Story." And I think we chose that title because it's a theme that runs through where this research looks at the experience of the justice process end to end. So it's a bit of a zooming out. And looking at from the reporting stage right through to afterwards, and just remembering what that is for a victim survivor in terms of the time it takes up and the all-consuming nature of that experience. I'll throw over to Francis. We're going to be doing a bit of a tag team. We haven't practiced, so it might not work, but we'll see how we go.
We've talked a lot over 2 years.
Yeah.
I think we'll pull it off. So as we mentioned, this was a kind of sister study to the transcript review, where it was an interview piece, and there were two components to this research. So there were focus groups conducted with 118 informants. So they're stakeholders who are either involved in direct support or advocacy of sexual offence matters, and they were drawn from sexual assault services, New South Wales Police, cohort-specific services, so those who work with people with disability or the LGBTIQ community, sex worker advocacy organisations, First Nations service providers, women's health centres. We really took a broad approach with the organisations that we spoke to.
And then the second component was qualitative research with complainants of sexual offences. And this was we spoke with 34 individual complainants over a broad range of circumstances, backgrounds, from right around New South Wales, different areas, and drawn from very, very diverse recruitment pathways. So we spoke with people who worked in any range of professions, from sex work through to the legal profession. We spoke with people with disability. We spoke with people with mental illness. We spoke with people who identified as LGBTIQ, with First Nations people, with people on around stable visa situations. So it was a real privilege to be able to speak with such a diversity of participants and for them to share their story with us. So just to take you through, sort of to give a bit of a pause, and Boxer asked us to sort of flag this part of the process because it's an interesting thing when you do qualitative research, which is what I do all the time with people who've experienced trauma and come into contact with the justice system, right? So that's what primarily my work involves. But it's not an easy task, and it has to be done really carefully, sensitively and appropriately so that we do not enact further harm. I don't think that research is a passive intervention, even for people who are not experiencing trauma and instability and complexity in their lives. But it's a it can be a negative intervention, but can also be an incredibly positive experience when handled in the right way. So we recruit through services who are already working with people potential participants in a variety of ways so that they can have a lens on their circumstances, the potential for re-traumatisation, potential for things like family violence risk, which is very real and live in a range of participants, regardless of what we're talking to them about, but also thinking about support needs, communication needs, and their safety and their privacy in terms of how the interview is conducted. So people might prefer to have an interview in person, but if they elect to have an interview online or by phone, we want to make sure that that's happening in a safe and private way so that that's not being overheard by somebody else. So we take a really tailored approach. We work with the services, and we want to just acknowledge the many services who were recruitment pathways working with us, both sexual assault services and a range of other diverse organisations, to set up that process. And then we make sort of gradual contact with the participants to work with them about what's going to be appropriate for that. For us, we're based in Victoria, so it involved quite a few trips back and forth to make sure that we were speaking with people in the way that they wanted that to occur. But then we keep the assessment and the conversation going. So often we'll speak with participants quite a lot beforehand to answer their questions, to find out sort of really, for them to get to know us before we get to know them. And then we make sure that we keep in contact afterwards. So these interviews happened the sort of second quarter of last year and into the first quarter of this year, and I'm still in contact with quite a number on a weekly or fortnightly basis, because we want to make sure that they're experiencing the research process as kind of opposite to what they experienced as the legal process, but we'll get to that now.
Thanks, Elena. So in presenting our findings, we tried to present it along the spectrum of the justice process. And starting off with before making a report. So even though this research was looking at complainants, so people who are involved in the justice system, just the nature of this research means that we ended up discussing what some of the barriers are for people to make a report to police, whether that's a formal report or taking advantage of the SARO option. And so some of those societal factors are things like victim survivors either blaming themselves for what they were wearing, how they conducted themselves, their relationship with the perpetrator, or feeling shame about how they responded to the offence. We also heard that they don't necessarily see their assault as serious enough to warrant reporting. This then extends in how the community sees sexual offences, and all of this keeps tying back to that idea of real rape that we heard about already. And so if it doesn't fit those ideas of what a real rape is, victim survivors may fear the judgment or the blame or the questioning that they might get from their friends and family if they were to disclose even to them. And then leading on from that, victim survivors can fear the social repercussions of reporting a sexual offence. This is particularly the case where the perpetrator might be a partner or a member of their local community. And this is particularly felt for people who are First Nations or who are from smaller, close-knit regional and rural communities. We also heard from complainants that the increased profile of sexual offences recently and very detailed media reporting of high-profile cases acted as a deterrent.
Absolutely. So we certainly heard from many victims, obviously the complainants we spoke to fitted a certain eligibility criteria. There were people who had reported, and we acknowledge that the majority of people don't. And there were people who had reported within a certain period of time because we were wanting to look at the contemporaneous legal process. But lots of people told us about the fear and hesitation they had in coming forward, even when they didn't have some of those societal barriers that I'm now about to explore. But for those complainants who were from marginalised or disadvantaged backgrounds, the barriers were just profound, as you would expect. So particularly for victim survivors with previous negative contact with police, often in relation to complex support needs, they might have mental health, substance use, even disability, where those things converge and mean that they're known to police and have a certain level of visibility to statutory systems. We heard about, I think as was mentioned before, victim survivors of visa arrangements or other unstable immigration status who were very, very worried about what they would do, and there were, for good reason, because we had some really concerning examples where there was even follow-up in some circumstances to sort of try and unwind their visa status as a result. We heard from people who identify as LGBTIQ about some incredibly stigmatising and minimising responses when they reported. Where they were identified as male, that was a response was received that, well, you're a dude, why didn't you just fight back? We had that sort of sense of, well, if you're a lesbian woman, then, you know, that you must be angry and you're just out to get the world. Those kind of really tired tropes that just you would think that we would be past, but were just coming up over and over and over again. For victim survivors who engage in sex work, huge barriers there. You know, in terms of just hyper-criminalisation generally, as well as that sense then, oh, not only are you coming to me reporting an offence, but you're reporting a sexual offence, really, and that minimisation of what that involved for them. And, of course, victim survivors from First Nations communities who said, you know, by far and away, we are not going to report to police. We're going to look more broadly to members of our communities, because for all of the implications, both historic and ongoing impacts of colonisation, over hyper-policing, hyper-incarceration of communities. So you don't want to be seen to be contributing to that further incarceration of members of your community. We also, but nonetheless, and this is one of the things I just want to kind of, I suppose we'll get to in a minute, but really kind of bear in mind that a lot of the time we talk about sort of sexual offence prosecutions not going forward because the complainant withdrew their statement, right? This is not what we found. We heard about lots and lots of reasons that victim survivors got up the courage to report. Nobody thought it was going to be a walk in the park. No one sort of skipped into the police station thinking this is going to be a lovely conversation. But they just made the decision to do it for a range of reasons. And contrary to what public or broader kind of community opinion might be, there were only a very small number who were looking for a negative consequence of some kind for the offender. More generally, the reasons, and you know, fair enough, even if they were, but more generally what was striking about this, what the participants told us, is that they were looking for an acknowledgement. They were looking for somebody to tell the offenders or the accused that what they had done was wrong. They were looking to be believed. But more than anything, just by far and away, the greatest reason was to protect future victims. So that's why they said it. If I know that this is not going to get me anywhere, but if I've reported, maybe the next time this is going to be on the record and something will be done. Or similarly, I saw him out with another woman and I just can't let it be on my conscience for that to happen to her. So that was a really, really striking finding, that nobody had any particularly positive expectations, but they were trying to do something for somebody else. And that's the reason that these participants also were involved in the research. So there were some good news stories, right? So we did have participants describe positive experiences of reporting, and there were absolutely strong and consistent features of those experiences. They were having a safe and private space in which to be interviewed, rather than being expected to relay the entire account at the front desk, which was often the case for some participants. It was having a female officer available where this was the victim survivor's wish. And here I just want to say, this has to be the whole way through, not just kind of being brought in at the beginning and tick a box and then, oh, sorry, she's busy now. Being questioned in a calm and respectful manner that indicates that the victim survivor can take their time. Being listened to and feeling believed and supported that they were doing the right thing in reporting, because that was definitely not the case with a lot of participants who spoke to us. And having a consistent detective throughout the investigation with whom they could build on an ongoing relationship and feel like they were committed. So when there were those examples, including where, those small number of matters actually made it to the trial process, and even if that trial didn't result in a conviction, the relationship with a detective that had been with them the whole way through and who believed them made a real difference in terms of how they sort of received that verdict and sort of what the fallout was for them then. But despite the positive experiences, it's important to note, this is really, really crucial, that a positive experience at one point doesn't mean a positive experience at other points. So we heard from participants who had a great reception from the initial report, really, really kind, calm, sensitive, but then went into the investigation process and the detective was really not responding to them with empathy and just not interested at all. Or the other way round. We had a really negative initial response, but then a positive specialist response came in. But it wasn't always specialisation, and trauma-informed responses didn't always go hand in hand. And the one thing I would say before I hand over to Francis for the next bit, we only had one participant who would characterise their experience as positive the whole way through. Now, thinking back to what I was saying before about attrition, or that idea that victim survivors withdraw their complaint, that participant was the only one who actively made a decision not to go any further. She'd had a really, really positive, supportive response, but made the decision because she felt it was her decision, because she felt empowered, she felt believed, and she went, no, this is not right for me in my community, but somebody has believed me, and that's enough for me in this situation. So just something to bear in mind.
And now onto the factors that can lead to a negative experience. This is still during the reporting stage with police. So there were multiple informant groups, including police, sexual assault services, legal services, that noted that the nature of questioning can make complainants feel blamed for the sexual offence. And police talked about the challenge in getting the balance right between getting the information that they need for a thorough investigation while also not distressing the person reporting. And detectives also noted that for some complainants, this could be their first interaction with police, and within the environment of a police station, the entire experience can be quite intimidating. The police stakeholders that we spoke to for this study acknowledged the importance of having a trauma-informed approach, but I think it's worth keeping in mind the method that we use. So for speaking with stakeholders from police, they opted in to this research study, so I think we can make an assumption that the people who participated from police have a greater awareness of issues relating to sexual offences, more experience in dealing with sexual offences. We spoke with people from the sex crime squad, and so that may not necessarily be indicative of the broader response from officers. And indeed, when we were speaking with sexual assault counsellors and other support services, they noted that a lot of police were not always familiar with how trauma can impact on a person's behaviour. So that idea of fight, flight, freeze and fawn, and that notions of a real rape, again, we heard examples where police would misunderstand someone physically shutting down during an assault or being nice to the person who assaulted them afterwards, not seeing them as protective factors for the victim survivor.
And obviously, as I alluded to before, we've heard about the confronting nature of going into a police station or making a report one way or another. We heard about great examples where detectives came to the victim survivor and then drove them to the hospital to get a forensic examination and then drove them somewhere else. But we also heard a lot about people having to front up to a station, give the details over the front desk, particularly negative responses when the sexual offence was happening in the context of family violence and ongoing relationships, not really an understanding of what that what that meant. That physical environment, which is incredibly intimidating even to people who haven't been through a trauma, as we've covered the nature of the questioning, and I think that goes to the study that Luke and Julia were talking about. But this is just one, so very consistent themes there with the initial police report, as well as what we were hearing in that study. But also, this is just one I want to highlight, that recognising sexual offences as a significant crime. And this sort of goes to the heart of the challenge, really, where in this case, and this is not just dumping on police, this is the bit where we're talking about that part of the study, but there is that sort of recognition, well, sexual offences generally involve a victim survivor and an alleged, an accused, and it's one person's account over the other, and that whole sense of don't convict on the basis of the evidence of one witness. And so police generally, or victim survivors, were getting the impression way too often that we know from the get-go that this is too hard. It's not going to be the hill that you're going to die on, that barricade the police are going to go to, because they know they're not going to get the conviction. So it's better to spend your time on other offences. So we even had an example of a victim survivor who followed up after their initial report and thought they were going to give the next part of their statement. But we had police saying, oh, you live on that street where that really violent offence happened, didn't you? I think, can we just talk to you? Can we get the CCTV footage from in front of your house? Can you find? And they ended up being kind of a witness to somebody else, another offence, because that was what was deemed. They were going to get a quick kind of win there. So I just want to, again, despite these negative experiences of initial reporting, the vast majority of participants wish to persist with the process and go to considerable lengths to see this occur. And as one said to us, if I'm going to take that step of going to the police, which is a horrifying step, I want something to be done once I've taken that step.
And that leads into our next tranche of findings, which is about attrition that happens at the point of reporting. And while for most of our findings there was a great deal of consistency between what the informants and the complainants were telling us, this was a point of divergence in our findings. So our consultations with informants suggested that this is when complainants choose not to go further with the legal process. Police noted that they'd explained to complainants that it's unlikely to result in prosecution. This is particularly the case for historical offences. And police also noted that they have high caseloads and competing priorities. One noted that they can have 15 to 20 sexual offence matters assigned to them, and that can impact on the level of support that they receive from police.
Yeah, and that goes to that sense of, well, where can we get quick wins over where do we think that we're not going to get a result? But we certainly heard that really, in the majority of cases, or for the victim survivors we interviewed at least, matters not progressing were the result of the complainants not hearing back from police and eventually giving up because it was too distressing to try and follow up and getting a different answer all the time. Obviously, police or prosecution choosing not to progress the investigation, and obviously the public interest has to be taken into account in terms of considerations about whether the likelihood of conviction. That's really important. But then the question is how the victim survivor is brought into that discussion and informed. But reflecting again, the real rape myths, we heard that police appeared to be more inclined to respond respectfully and proactively where the assault fitted that real rape idea. So that participants felt judged and shamed in instances where they were making a report that was deemed historic. But I want to say, we're not talking years ago, we're talking more than 3 months old. Okay, so that's what victim survivors were being told. Your complaint is historic because it happened more than 3 months ago. When they were engaged in risk-taking behaviours, where they'd invited the accused back to their home, As one participant said to us, an invitation to my house is not an invitation to my body. But that was certainly what they were made to feel by police. And absolutely where complainants were affected by alcohol at the time of their offence. So there were lots of responses to victim survivors of, what did you learn from this? How could you be so naive? And even response as well, I know about boy troubles, but you'll kind of get over it. So we'll move into the investigation stage now.
So we discovered a number of issues related to the investigation of reports and evidence gathering. The judicial officers that we spoke to in particular expressed concern about the quality of evidence in trials, often being led by the prosecution, which could be traced back to that initial evidence gathering by police. They discussed the variability in evidence in cases and in the conduct of medical and forensic examinations. And so we heard issues around the access and availability of medical and forensic examinations for people who live in regional and remote areas, but also for people who live in metropolitan Sydney as well. So in regional areas, victim survivors can be required to travel hours to their local hospital to undertake an examination. In some cases, the only transport that was available to them was in a police car. And even in metro areas, victim survivors could be required to travel from hospital to hospital in order to find the right medical professional who was available to conduct an examination.
And we certainly heard from complainants that where they were able to access the examination, again, it wasn't a walk in the park. It wasn't something that they were happy to be doing, but it was where they were able to access it. It was handled very well, and it was also importantly, and as you know, New South Wales Health would stress, it's an avenue, it's a doorway to other support. So that was key. That, well, I went and had that horrible thing happen, but I knew that that was part of the process, but I got this great counsellor. And that was really important, okay? But we heard about lots of times where just they were not aware of that's what they should do, but nor was anyone around them. So even GPs were not aware, when they're often GPs the first to whom people will disclose. Also general crisis lines and things like that, where people say, I'll go home, have a cup of tea, have a shower, have a sleep, all the things that, you know, as lawyers, one of them, or anyone working in this system know is not what ideal in terms of gathering forensic evidence. So that awareness was really a key piece that jumped out at us. But then more generally, I think this was really striking. I sort of wasn't worryingly, depressingly, I don't know, I wasn't all that surprised about the response, the initial responses to reporting. The bit I was more surprised about was the variability in investigation and the extent to which victim survivors were having to chase and chase and chase and chase, and particularly about interviewing of witnesses, gathering of evidence, you know, just your bread and butter policing work, just seemed not to be happening. And I'm sorry for this triggering example, but it's really a good illustration. That included, in the case of a young woman who was raped by multiple people, or alleged rape by multiple offenders, and where the police then went and interviewed one, or talked to one on his doorstep, who said, oh yeah, well I agree we had sex, but no, it was all consensual. And so the police came back and said, well, I spoke to the nice one, and he reckons that it was all consensual. And this complainant said, well, what do you mean the nice one? Oh, well, he told the others to leave. And she said, well, that's the point when the strangulation started. So that officer knew that, but this is what I'm talking about, that sort of sense. So that particular case, which could not have been more stark, where there are examples caught, the parties were caught on CCTV, she had information about who they were and where they lived, only spoke to one witness and not in a formal interview. So that was really striking for us about, well, if you're not going to follow up in that sort of situation, where are we going to follow up, folks? moving on to during trial. Oh, that's me too. Okay. So, again, during trial, we did hear about some positive experiences. The hallmarks of those were ongoing support, again, through those dedicated detectives I mentioned, having access to specialist counsellors. Now, those specialist counsellors we heard are amazing, but sometimes it's a bit of a challenge finding the right one, someone with experience and understanding of trauma. But once you find them, they're sensational, but they're slammed, all right? So they can only kind of stay with you for a certain period of time. So we heard about SAS New South Wales counsellors staying with people well beyond their remit, just out of, really going above and beyond, and the importance of peer networks and support. So, but we also obviously heard about, total confusion, about lack of clarity on what the court process entails, lack of consistent support during the trial process, because remembering there's only so many people you can talk to about so many things when you're in the process of examination. You can't go and have a debrief about what did that mean. And just the general shock, this won't come as any surprise to the people in this room, but it came as a complete surprise to pretty much every participant, the just astonishing realisation that they are not the main party in this game. They are just a witness. They are not at the centre. And so we all understand the reasons for that, but that's a very, very distressing realisation. We certainly then heard about the really, really confronting and humiliating process for complainants in cross-examination. And I won't go into that except to say possibly that the rule that we were talking about where complainants essentially have to be presented with the accused versions of events was summed up by one participant and said, well, at first I was examined for a day and a half about what did happen, and then I was examined for 3.5 days about what didn't. But just understanding why that was happening and support around that was lacking.
Oh, I didn't mean to skip. The informants also supported those findings as well and raised a few additional matters that complainants can sometimes have to travel long distances to appear at court, and they can be separated from their support networks. And then they're in very close proximity with the accused and the accused support networks, and we heard about instances of harassment that can occur between the two parties as a result of that. So post-trial, the overall impact of participation within the trial process was seen as quite re-traumatising for complainants, which would be quite unsurprising having just heard our first presentation. There's also a lack of post-trial support for the few that we spoke to who went through the process. And there's a tension between expectations of justice and the verdict that they receive during the trial. The low conviction rates that can be received led to a majority of the complainants feeling quite disappointed in the outcomes of their trial, but we also heard about disappointment from those who received a guilty verdict because they didn't feel like their expectation around being believed and being heard was something that they received. Yes, I'll hand over to you.
Yeah, and I think that's really telling in terms of what the wider public expectation might be around what the purpose of these trials are or what people might want to be getting out of it, and what the reality is. That we had people say, well, the accused was convicted and they even had a custodial sentence, but the one thing I wanted to get out of it, didn't happen. Nobody actually said this was wrong to me. Like there was no point at which I felt that he knew that that was wrong and it wouldn't happen again. And so, but also that sort of sense of, as we referred to before, that this has been the story in their lives for often way too long, years, huge delays, and that then just what happens is that, oh, well, we've dropped, finished, bye, see you later, regardless of what the verdict is. And we had one participant had no idea what the outcome was, even though she'd been there, because nobody had explained it to her. So I was trying to ask her about the order or no idea. She couldn't understand it because nobody, and nor could a counsellor, because nobody had been talking them through. But the other thing we have to remember that is a conviction is often about a certain aspect of the complainant's experience. It's where somebody is pleaded, it's a conviction on the basis of the offences to which they've pleaded. So one gave an example of, well, I was raped and there was a physical assault as well. He was convicted for the physical assault, but not the rape. Then I had to talk about, gave my victim impact statement, but I could only talk about the impact of the offence for which he was convicted. How am I supposed to determine which of the impacts relate to the physical assault and which of the impacts relate to the rape? And we had similar examples where, complainants had where a statement of facts becomes reduced down to on the basis of the guilty plea. Well, we're making this plea because we agree that these things happened. But in the process, we have to say, oh no, she wasn't passed out, she was resting. She wasn't physically injured. She was, all these things are negotiated away. So the statement of facts becomes for the complainant not at all the facts of their experience at least. And notably, right across the study, the interview participants and the informants, the many, over 100 working in the system indicated that they would be likely to report a sexual offence or to encourage a family member to do so. Unlikely, sorry, yeah, very important distinction. Unlikely to report a sexual offence if they or a family member experienced it.
And we've got 5 minutes left, so I'll try to go quickly through this. But I do want to call out that even though it was an explicit line of questioning, most, if not all, of the informants that we spoke to reported that the system was broken or something to that effect, and knew that the response that they were providing wasn't right and knew that they were re-traumatising people in the process, but felt hamstrung by the system that they were operating in.
So we get to the recommendations, Okay, so these are sort of quite broad recommendations. A, because we're sort of spanning the end-to-end process, and B, because we do understand and recognise that there's a lot of work been happening in this field and continues to happen. But that said, as the previous study highlighted, that just because there's been legislative reform or other refinements in the legal process doesn't mean that they're being experienced on the ground. And doesn't mean that the culture is key in terms of how those reforms are enacted. So we definitely talked about the importance of targeted public awareness campaigns, and I think that's nothing new, but we've found sort of particular nuances to the way they need to be directed. And in particular, as the establishment of a model of care which connects victim survivors with a consistent source of support the whole way through. And that's not rocket science, just having somebody to talk to from the beginning who stays with you right throughout. So they can be your advocate, they can connect you with services, but also you don't have to tell your story 15,000 times. Do you want to keep going?
Sure.
Okay. Or do you want me to handle that legally? Yep.
Yeah.
Sorry, just being the lawyer. It's an interesting thing where we often hear about, maybe complainants in sexual offence matters or victims more generally in the legal process need to become a party or have their own legal representation. We're not suggesting that, but what we found was complainants had a real need for access to legal information regarding the legal process. Nobody was there to tell them this is how it works, this is what this means, this is what your entitlements are, this is why the limits are there, and talk it through. So having that access to and support on particular procedural issues is really, really important, which we know there's a limited, a targeted service in New South Wales, but it's quite restricted to particular procedural issues.
And we have a minute left, so I'll speed through the last of it, but we've broadly recommended training for police and different actors within the legal process. Our research captured a part of a complainant's experience, so we acknowledge that there are other parts that warrant investigation. We heard about support services that already exist for complainants, but we heard about challenges within them, and so I think that that would be beneficial if there was a study into the demand and funding and service model of those supports. And finally, I just want to acknowledge that this study was a real team effort, and all of us were immensely privileged to do this work. And we thank Boxar for commissioning this really important project and want to acknowledge the informants and the victim survivors that we spoke to who were so generous with their time and with their insights for this study. Thank you.
Thank you so much, Elena and Francis. Well, I'll throw over to questions, but I've been asked to make just a couple of comments here. I think we see from that really broad-reaching report so many of the findings that Luke and Julia had in their sort of microscopic, detailed forensic analysis of one aspect of the justice system. If you telescope out, so many of these things are exemplified, and in particular exhibiting a lot of those rape myths. The scope of your project was, of course, so much broader than the trial, and a number of the issues focused on the specific needs of First Nation victim survivors, as well as other cohorts maybe who are particularly unlikely to get justice where they don't conform to the notion of the perfect victim. The recommendations, of course, are broader in scope, need for police training. I don't know if you caught that in the short time available. Training for people like GPs, that notion that you would be encouraged, and Lifeline and the like, the notion that you'd be, well, you can have a cup of tea, but have a shower, that's really problematic, obviously. The further exploration of restorative justice, that's the Centre for Innovative Justice has done work in that space in the past. If that's something the victim survivors are calling for, we really need to be considering that. In the ACT, we already have some of that. Taken together, those recommendations, I think, reinforce the finding in Julia and Luke's report that the reforms of the last 40 years have attempted only modest incursions into the essence of what makes sexual offence trials so traumatic for many complainants, including the adversarial nature of proceedings. So I think we're at a stage of really having to grapple with the very basis of, do we need a serious rethink rather than just tinkering around the edges? And with that, I think we should throw it over to questions. There's a roving mic. There's up over here. And please indicate where you're from and also whom your question is directed at. It might be for all members of the panel.
Thank you. So my name is Matt Carpenter. I'm from the Department of Communities and Justice. I've got a question for Luke and Julia. But for context, my background is as a trial prosecutor with the Director of Public Prosecutions, and I've run a number of sexual assault trials. So my question is, how do we rationalise the need to shift a paradigm away from the behaviour of a complainant and perhaps away from assumptions or presumptions about complainants lying and their behaviour with that very fundamental principle that the Crown has the burden of proving all of the aspects of its case, including that the sexual act occurred and that the complainant was not consenting and that they're not lying about it. And I say that being very aware that judges are very quick to pick up if a prosecutor says something that might imply or suggest that an accused has to disprove the prosecution case. And so prosecutors are very cautious to avoid that. Yeah. So that's my question. How do we reconcile the need to shift the paradigm without interfering with that burden on the Crown?
So, look, I think there are a series of questions, obviously, within that overarching question. But I guess one of the things that was very apparent to us when we were doing the trial transcript review was, firstly, that there was a lot of evidence, and presumably this is in part because of the way the police brief comes to the prosecutor, that really didn't appear to be necessary, even if strictly relevant. And so I suppose to the extent that any agreement can be made about, for example, whether or not, and you may not necessarily know this as the Crown, things like sexual intercourse occurred, but the real question is about non-consent. So there just seemed to be a lot of evidence that was being led that was formulaic, and we saw it again and again in each trial, strictly not really going to elements within the offence. So that's one part. I think another part, though, is that we really didn't see the Crown grappling with the idea of what free and voluntary consent, how that might be reimagined, other than to fall back onto questions that continue to emphasise how the complainant may or may not have resisted, both verbally and physically. Now, it seems to me that even where an opportunity was given to a complainant to explain why they may have stopped resisting, you're nevertheless harnessing that aspect of the attribute. And we have shifted this definition, so I do think the Crown has a duty to try and reframe the case more closely to imagine what that could look like. And of course, since last year we now have a concept of affirmative consent. We've got the added provisions that a complainant doesn't have to do or say anything to indicate non-consent. Certainly our study in Victoria, we found that even though an equivalent provision has been in since 1991, the same questions were being asked. So you didn't say anything, no. Didn't do anything, no. So I guess we need to sort of reimagine how you're focusing on free and voluntary agreement, and also, in part, the other part of the case. And obviously Crowns have to, play a difficult role there, because they also don't necessarily know what the accused case is going to be. So I do think removing some of the potentially unnecessary evidence, because it keeps the complainant on the stand much longer, and then trying to focus things more closely on what actually has to be proven, because you don't have to prove that the complainant was distressed after the event, albeit we did find much of the Crown's evidence went to that. You don't have to prove that she resisted or he resisted, yet much of the questioning was about that. So the elements don't require that, yet we still focus in on them. I accept it's not an easy task, but I think there's some starting points there. Did you want to?
Thank you. I'll just add, I'd love to see in a few years' time this revisited to see if those affirmative consent reforms had a different outcome in the way that trials are run. Hopefully, as a policy person, not a prosecutor.
There's a question right up the back. And I guess the point is, if there were a ground rules framework, and obviously it would need to be done in a way that does not derogate from the defendant's right to silence, the Crown would have some vague sense, and you have to walk that line very carefully around what's in contention. Yeah, you've got
trial advocate from the Director of Public Prosecutions. So moving it to the space of child sex, which is mostly what I appear in, like 90% what I prosecute. Thank you for making me a better advocate. I'm a big girl fan of all of you up there. I read all of your research. It helped shape my opening and closings, but I'm feeling deeply, deeply troubled about my future career, and you probably did look at some of my trials. But anyway, with that disclaimer, you're constantly saying to a jury, in closing particularly, this rises and falls on this complainant. You'll accept them as both a credible witness, as both honest and accurate. That's a hallmark of someone who is credible. someone you can anchor and hang your hat on their evidence, because you have a word upon word version. You don't have a lot of corroborating evidence. Some of those topics that you've said about clothing, first complaint evidence, are really, like when we play both sides of the coin, isn't necessarily a bad thing when you're asking the jury to accept that person's evidence of what happened in that closed room that nobody saw. The clothing might have been hard to get off. There might have been an indication of a struggle with bruises. The first complaint might be wholly consistent in the SAKE report or to the nurse or to whoever. And I'm talking about where you don't have an issue of consent, where you aren't really dealing with a lot of the other myths. Some myths, yes, with children, absolutely. And you're asking the jury to accept this version. So how is it, do you then say, in a closing address, when they are the high point of your case, that you can't go to some of these topics that would absolutely be confirming a myth?
All of the stuff in your study was dealing with adult complainants in both these projects. I'm not sure that
we haven't studied at all either the child sex pilot list or child sexual assault cases. Ours are all directed at adult complainants, so I don't know that I feel terribly well positioned to comment on a child sexual assault trial, which I think raises very, very different questions, albeit...
doesn't turn on consent.
Yeah. But I don't know if your study was only...
Our study was limited to adult sexual offence complainants, but I think it's just, I suppose, just goes to that broader issue, which is not potentially going to be very helpful to your line of work, but just highlighting sort of the challenges of the adversarial process more generally and how it really is very poorly designed to be able to respond to matters of this kind. And that doesn't mean that there shouldn't be accountability, but it does mean that there need to be exploration of other ways in which people can feel believed and other ways in which people can be held accountable. That may complement the process where the adversarial process doesn't either go the whole way through or doesn't end in a conviction, or may end up being an alternative because it was decided that there was no likelihood of conviction in the first place. And that's why, amongst other things, we do recommend exploration of restorative processes because, again, it's that sense, you know how I referred to that one participant out of 34 who decided of her own volition not to proceed because she said it was enough for me that I felt believed by the people with whom I spoke. But there were all sorts of things going on there. She was supported by family. She, she was surrounded by belief. She was surrounded by an acceptance that this harm had happened to her. She was also surrounded by a very, very supportive detective who went and spoke directly to said alleged offender, and she felt that because of what she knew of that person, that was significant enough. So I'm not saying that's an alternative. I'm not saying for a minute we throw out the process because I think we should never let it off the hook ever. But that's why our whole CIJ exists, which for our sins. But it's just a sort of highlighting if we can't get where we need to go with that process, what else are we exploring at the same time, I suppose, to be companion pieces? It's not really a helpful answer to your particular area of practice, though.
I'll throw a curly out then. Taking it back to adults, where freeze is a very common response, and we have great directions, and the layperson on the jury understands that you can freeze. We've come a long way, thank God. But still, you are asking a jury in a closing address to accept them as a witness that is both honest and accurate, that didn't say anything, and we all understand in this room, as educated people in this space, that we don't need to explain that further. When you do, though, to that layperson in the jury, or 12, have to explain the concept of freeze without any expert report, you have to go to other signs, and those categories are the forensics, the type of clothing, whether they could get the clothing off, who was there, who did they tell, what was their response, when it is the burden of proof, which is high, beyond reasonable doubt, to reject the accused version that it was consensual when they didn't say anything? How is that person in their mind supposed to know if someone's not consenting? So I think it's really difficult. I don't know if the research could drill down into specific, like, response of freeze, because it's incredibly difficult then to meet that beyond reasonable doubt task without going to those, what are awful myths that we have to go to in that double-edged coin. Any suggestions?
Can I just zero in on one issue that you raised, that when you said without expert evidence? I don't get why we don't have more expert evidence about, you know, the responses of trauma played out in legal processes, because it's so essential. And what struck me in this research is that, so I was involved in the interviews with judicial officers, just because I do it a lot, so I can give them a bit of a hard time if I need to. And there were lots of goodwill, great, working hard, very well intentioned, worried about the process, all the things that Francis was explaining, but no grasping of what the broader evidence base was, which was really striking. And I think it's because as lawyers, we think that evidence means something that's brought to you and trotted up and presented and tested, rather than a sense of what we are discussing at this conference about what an evidence base is more broadly. I think there's a bit of a funny disconnect there. So that's one thing that I think needs to occur more broadly, and I think there needs to be kind of a greater recognition of expertise, because we also then tend to rely on sort of this clinical expert, and this is without kind of drawing in wider disciplines and understanding. And I see that all the time in my work, which is, I think, is a real concern. I might, if Julia or Luke had another answer to other things that we can do.
I think we might see if there's a question. Yeah. Just down here. Thanks.
Hello, my name is Claire Grundy and I work in domestic and family violence. I don't know so much. I do have one question, but I probably have some comments. Those comments really relate to...
Could we just start with the question? Sorry, we've only got a few minutes before the break.
Sure. Yeah, yep. So I'm interested in knowing the gender ratio of the participants for both studies. Were they male, female and gender diverse people included in those studies? Or...
I can answer for the 34 participants. We had one who identified as cisgendered male, one who identified as male at one point, a gay male, and then a trans woman later. They experienced multiple assaults. Other than that, the participants, through very, very broad, non-gender specific research, recruitment pathways, were all female.
Yep, thank you.
And in the transcript study of the 75 trials, there were, I think, 78 complainants in total, and I think 6 of those identified as male.
Yep, thanks.
Thanks. To your comments.
I do want to say, look, you know, it's a deeper issue, I think, and I'm actually really thankful that it's a difficult topic to present on as well. Sexualised violence, it's emotional, it's raw, and I also think, you know, Elena, you touched on a couple of things during your talk. You talked about one incident of it being quite triggering. I actually think a lot of that content across the two were quite triggering. And I think for somebody in the domestic and family violence field I think a bit of a trigger warning could have been, you know, we look around this room and we know that 1 in 5 or 6 women and 1 in possibly, I think it's 16 or 19 men are victims of sexual violence. So I just think some of that content was really quite like, wow, you know, transcripts, they're court transcripts, some of those are participants' comments. But I appreciate, I'm grateful you went there. It's just, some of it was quite,
Yep.
you know,
No, that's
it can be triggering. The other thing I do want to say is that I think it is deeper. I think victim blaming is absolutely pervasive in our community and our society. And I think and I know I'm coming from a legal standpoint here. I'm coming from probably a deeper look and looking through a different lens, which is really about education, our attitudes, our beliefs about gender-based violence and victim blaming. And I think that in a lot of the language that's used is really about victim blaming. And we've got to make a change there for ourselves and for our kids and for our friends and the people we love.
Well, I think that's what underpins a lot of
Thanks.
those rape myths.
Can I just respond to one point? I absolutely think that's a fair call about the trigger warning. With all of our research, I tend to go pretty hard, and that's because I want policy people to to hear it. But the other thing I want to acknowledge that it's not just triggering about hearing about the content, it's hearing the same, for people who work in this system, hearing the same things over and over and over again and hearing that nothing is changing or not enough is changing is incredibly distressing. So that's why we definitely reflected that, and that was why it was so important that Boxar commissioned research that was talking to people working on the ground and people experiencing that process who all with a few minor points of diversion said exactly the same thing. But those stakeholders would say to us, well, we've been saying this for decades.
Absolutely.
And, hopefully this will mean that people...
Hopefully we won't be still saying this
in
decades to come.
That's right.
Please join me all in thanking our panel.
Thanks, Lorana.